Thank you. Good afternoon. Please be seated. All right, we are on the record in 23 CV 50050. And Mr. Thompson, good morning. Good afternoon. Good afternoon. It is, we are past the noon hour. Good afternoon, sir. And with you at council table, is that Ms. Thompson as well? Yes. All right. Good afternoon. Mr. Steele, good afternoon. And Mr. Steele, are you appearing in the 23 CV 49245, correct?
That is correct.
All right. And that matter is docketed for a 3:30 start. I understand there is the motion to consolidate. And is it Ms. Kuchera?
Yes, Your Honor.
All right. And you have filed the motion to consolidate, correct?
That's correct, Your Honor.
All right. I know there's an objection from the Thompsons regarding that motion. I didn't see, Mr. Steele, your position on that motion.
I have no objection, Your Honor.
All right. Ms. Kuchera, I'll hear argument regarding the motion to consolidate first, and then I'll hear from the Thompsons on their objection.
Thank you, Your Honor. For the record, Stephanie Kuchera for defendants in case number 23CV 50050, Lisa Andrach and Fitch and Neary. Your Honor, the motion for consolidation is appropriate under the circumstances under ORCP 53A. Upon motion of any party where more than one action involving a common question of law or fact is pending before the court may order a joint hearing or trial of any or all of the matters. This case arises from my client's representation of plaintiff's opponents in adversarial actions. The exact same situation is true in Mr. Reinecke's case. That is case number 23 CV 49245. The plaintiffs are the same. Mr. and Mrs. Thompson have sued the attorneys who represented their opponents or continue to represent, in Mr. Reinecke's case, their opponents, the Reeds. The question before the court is whether a party may sue their opponent's attorney and whether that suit may be viable given Oregon's anti-strategic lawsuit against public participation, the anti-SLAPP statute, which is found at ORS 31150. We filed this motion, Your Honor, because it makes sense for judicial economy and for consistency in the ruling to have the anti-SLAPP motions heard together. The defendants in both cases, again, are similarly situated. We concede that they didn't represent the Reeds in exactly the same cases and with exactly the same issues, but the legal question and the legal issues, Your Honor, are exactly the same. And that is whether the opponents, the Thompsons, can sue their adversaries' attorneys. The claims are the same, Your Honor, and the damages are exactly the same. And so what it appears, what is clear from the complaint is that the Thompsons are seeking the same damages for similar conduct against similarly situated defense attorneys and their law firms on the same claims: tortious interference, intentional infliction of emotional distress, and wrongful use of civil proceedings. So if the court, whatever the court's decision is on the anti-SLAPP motion, would be consistent across these two cases.
Thank you. Mr. Steele, did you want to add anything?
No.
All right. Mr. Thompson, is it still true that you object to the court hearing these motions at the same time?
Yes, it is.
All right. Sir, if you could stand to be heard. And what is your objection?
Well, essentially, everything that Ms. Kuchera said does not apply. These are not similar cases. They have nothing to do with the clients. They have to do with the actions of the attorneys. Lisa Andrach, her client, falsified a deed, forged a deed. All the evidence is here. That has nothing to do with Mark Reinecke's lawsuit for entirely different purposes. Just because we're the plaintiffs in both doesn't make them similar in any way. The facts are different. And, really one of the only similarities that I see here is that Ms. Kuchera has copied and pasted most of Mr. Steele's motion. And there are no facts about the case, so, they just don't relate at all. The amount is similar because they are both an effort to interfere with our property rights. So they're related to the value of our property. And that's the only similarity there. So this motion, if granted, would be highly prejudicial
All right.
to us, the plaintiffs, and also to the court.
How so?
Pardon?
How so? How would it be prejudicial, sir?
Well, I guess I have a number of concerns here. One of them would be that I have some questions about the representation. Who was paying for the defense of these people? It would appear to me to be their insurance company. So we have an insurance company footing the bill for the defense of all these people, which would be the Oregon State Bar's Professional Liability Fund.
Okay, but sir, I want to, whether or not that's the case, I want to direct you to my question. And let me just give some context for the question. Right now, we are going to hear the argument on the special motion to strike that has been filed in 23 CV 50050. So that's the first case, okay? So we're going to hear, I'm going to hear argument on that issue, on that case, and I've reviewed the briefings of both parties. Once we have concluded that argument, we're going to transition directly to the next case, and I'm going to hear that special motion to strike in 23 CV 49245. So really, the question that I'm asking you is, do you just want to make one argument all together so that I hear it all at the same time? Or do we want to hear the first one, take our 15-minute recess, and then we'll come back and we'll have argument on the second case? Does my question, and so if we do it the second way, we take a break and we hear them separately, how does that prejudice you if we do it in that fashion?
Well, the two just aren't related to each other. So there's no point in that. It would make things confusing for everyone, for me, for my wife, for them. Does Mr. Reinecke really want to get involved? At least the Andrach is forging of a deed. I mean, maybe he wants to. Maybe he's part of that. I don't know.
All right. Sir, I understand. I've heard you say that you would find it to be confusing. You are appearing pro se. And so we will, the motion to consolidate will be denied. We will handle them individually and we'll proceed at this time. So, sir, we are going to handle them separately. We're going to hear one. We will take a break and then we will hear the second.
Thank you, Your Honor.
All right. So we will take up the special motion to strike in 23 CV 50050. And Mr. Kuchera, this is your motion. So you will proceed. Go ahead.
Thank you, Your Honor. Just by way of brief background for the record, Lisa Andrach and Fitch and Neary represented the Thompsons' opponents, first in a Land Use Board of Appeals action, and then in an appeal of that LUBA action. The LUBA action and the appeal were filed by the Thompsons. This is critical, Your Honor, because when we look at the claims that the Thompsons have filed, one of their claims is for wrongful use of civil proceedings. And even if we could get there, which we can't, that claim fails on its face because of this reason, that they filed the actual litigation that they are now seeking to bring a tort claim for wrongful use of process. The first question, though, before we even get to what are these claims, is who are these parties and how are they situated? Under ORS 31150, the legislature passed law to prevent this very situation from occurring. When a party is part of a public proceeding, part of a judicial proceeding or other proceeding authorized by law, they are allowed to make statements. Those statements may be adversarial to the other party. And in this case, were necessarily adversarial to the other party because the attorneys, Ms. Andrach and her firm, represented the Thompsons' opponents. The only relationship between Lisa Andrach and her law firm and Mr. and Mrs. Thompson is that of the attorney for the Thompsons' adversaries. The proceedings that are at issue here are certainly judicial proceedings or other proceedings authorized by law. It was a LUBA decision and then the Court of Appeals decision on that LUBA proceeding. Ms. Andrach prevailed in both of those proceedings on behalf of her clients, the Reeds. What the Thompsons have now done is filed a lawsuit, and the only activity that is at issue, and the only activity that could be at issue, arises from Ms. Andrach's representation of the Thompsons' opponents in those judicial or other proceedings authorized by law. So the first prong of the statute, Your Honor, asks, is this the type of activity to which the anti-SLAPP statute applies? It certainly is. And if we look at, do you have my motion pulled up, Your Honor?
I do.
If you go to page 5, a party may file a special motion to strike, and we must first establish that the claims arise out of protected activity, expression, or conduct described in ORS 311502A through D. Here, it certainly does. And if we look at Part A, starting on page 5 of our motion, the case at bar, according to the plaintiff's own complaint, falls squarely under ORS 31150 because it all arises, every one of the actions, activities, the statements that were allegedly made by defendant Andrach are related to her representation of the Reeds in civil proceedings. On page 6, Your Honor, so on page 5 and 6, we summarize those portions of the complaint, the allegations that are at issue here. And, well, let me move on. The statements, the provisions of the statute, the anti-SLAPP statute, plainly cover statements made or documents submitted in connection with a civil case as it is being considered by a court in one of these judicial proceedings. And, for example, specifically, pleadings filed with the court are statements made by an attorney or a witness at a hearing, documents filed by an attorney on behalf of their clients. This is the Deep Photonics Court case, Your Honor, 282 Oregon at 533, a 2016 case. Again, the only statements, documents, or conduct that give rise to plaintiff's claim against my clients, defendant Andrach and her firm, were made within these legal proceedings. The Deschutes County Land Use Planning, the LUBA, the Oregon Court of Appeals. Therefore, they fall squarely within the statute. The next step, once that determination has been made, is whether plaintiffs could support their claim, even if, can they support these claims and submit evidence in support of these claims? And they simply cannot. The only, quote, evidence that has been submitted by the Thompsons are these two deeds that ostensibly were filed or drafted or were somehow created or part of Ms. Andrach's representation of the Reeds. Even if that were true, these documents submitted as evidence do not overcome the burden that the plaintiff has under the anti-SLAPP statute to establish that there is a probability that they will prevail on their claims. The first claim that they have filed, well, because of the situation and the parties' relationship to each other, plaintiff's claims are barred by the litigation privilege. All of the statements, documents, the activities that defendant Andrach undertook to perform on behalf of her clients are protected. And Your Honor, if you look at the Mancia versus Hansen case, it's 190 or App 412, a 2003 case. There's some really helpful language in this case.
Before you take me down the line of that case, there's a new case, I just had it, it's cited in your memorandum, 2023 matter. And it seems to the court that there's a footnote in that case that says that the litigation privilege does not apply across the board to all claims. Let me pull that up for you.
Sure.
The Davudian case, 327 ORF 197, and let me pull it up. I meant to have that with me on the bench. You cite to it on page 7 of your memorandum.
Oh, sure, Your Honor. We cite to it to state the privilege applies to statements or writings made during or as part of the litigation itself and to similar statements which are made by a lawyer outside of the pleadings and actual trial of the case if the statements or writings have some relation thereto. Is that the language you're looking at?
Yes.
And so, Your Honor, I agree that there are certain circumstances, and the case law certainly does bring up some circumstances in which an attorney's actions or statements, even if made on behalf of a client, would not be protected. This is not one of those, because those cases and those situations discuss when an attorney is behaving maliciously, is not behaving in good faith. There are certain exceptions that simply do not apply here. Here, we are looking simply at an attorney's, again, assuming for the purposes of today, that both of these deed documents were drafted by Attorney Andrach and filed by Attorney Andrach. Assuming that that is true, which it is not, but assuming it were, those statements, that activity would be privileged. Those were statements made on behalf of a client in the course of the proceeding, the land use, and then LUBA and Court of Appeals proceeding. Certainly not malicious, certainly not made in bad faith. But even if that were true, plaintiffs have submitted no evidence to show that it is. On the face of the documents, which is the only thing that the court can consider because that's the evidence that plaintiffs have submitted. And if we may want to turn to those deeds, Your Honor, because I think it is helpful. We attached them to our reply, file 130-2024. One of the deed documents was filed with plaintiff's opposition in the 23 CV 50050. The other was actually filed in response to the motion to strike in 23 CV 49245. But the only activity, and just so that I can make this very clear for the record, plaintiff's response in opposition to our anti-SLAPP motion at page 4, paragraph 4, states very clearly, insofar as this entire matter and this tort claim are concerned, the only items that matter are the property deeds. This, paren, all of it, end paren, is therefore an, quote, in rem action and has nothing to do with persons, only with land. It is irrelevant who the parties are who own the land. So here the plaintiffs are summarizing the body of evidence that is applicable, and they are stating the property deeds are the, quote, only items that matter. So if we look at those deeds, that's the, quote, evidence that plaintiffs have submitted. And again, they are attached as exhibits to our reply, dated January 30, 2024. The first is labeled Exhibit 4. It's a 4-page statutory warranty deed. There is nothing in here, Your Honor, that would support any of plaintiffs' claims. This is just a document that plaintiffs assert was drafted, and I believe they assert was filed by Attorney Andrach and or her firm. Well, okay, even if that's true, it doesn't.
And so is the argument, Ms. Kuchera, even if there was no litigation privilege, they have not met their burden.
Correct, Your Honor. Even if there were no litigation privilege, they have not met their burden.
Understood.
The second exhibit, Exhibit D, is a 5-page exhibit. And again, it's ostensibly a deed document that the plaintiffs assert was drafted by and/or filed by Attorney Andrach on behalf of the Reeds. So, Your Honor, if we go now back to, all right, set aside privilege. I think that makes sense. So even if she weren't an attorney who had this privilege about the statement she were making on behalf of her client, well, what is the quote evidence? This second hurdle that the plaintiffs have to overcome. What is the evidence they submitted? Well, they submitted these 2 deeds and admit that that's it. That's the body of evidence that is applicable to the court's decision today. And so let's move on to their first claim asserted against Ms. Andrach and her firm. The first claim is tortious interference. And what plaintiffs allege is that the deeds somehow caused an interference with their use of their property. The allegations are certainly not extremely clear. But again, Your Honor, if we look at the elements of a tortious interference claim, what plaintiffs must show is that they have substantial evidence to support a prima facie case, that they will prevail, and that they can prove every element. 1, the existence of a professional or business relationship. 2, intentional interference with that relationship. 3, by a third party. 4, accomplished through improper means or for an improper purpose. 5, a causal effect between the interference and damage to the economic relationship. And 6, damages. And this is at pages 9 through 10 of our motion, citing Porter versus OBA Inc., 180 or App 207, a 2002 case, which quotes back to the McGanty case, McGanty v. Staudenraus, 321 Oregon 532, a 1995 case. The only evidence are these deed documents that they allege Attorney Andrach prepared as part of her representation of the Thompson's opponents, the Reeds, in the land use, the LUBA, and the Court of Appeals case. Nothing about those deed documents on their face shows that there was any relationship between the Thompsons and a third party with which Attorney Andrach intentionally interfered. Nothing about those deed documents shows that anything Attorney Andrach did was accomplished through improper means or for an improper purpose. And there is certainly nothing in those deed documents that supports any claim for damages. If we move on to the second claim, intentional infliction of emotional distress, again, we're only looking at these deed documents. That's the evidence that the Thompsons submitted in support of their claims. They must support each claim using substantial evidence that they will prevail on the claim. And in order to prevail on a claim for intentional infliction of emotional distress, there must be evidence that the defendant's conduct constituted an extraordinary transgression of the bounds of socially tolerable conduct. Your Honor, there's nothing about these documents that shows any type of emotional distress, any type of intent. There is no, again, assuming that it's true that Attorney Andrach drafted and filed 2 deed documents, what is the conduct? What is the extraordinary transgression of the bounds of socially tolerable conduct? The issue of an intentional distress claim is a fact-based inquiry, and the only facts available for the court's review are, again, the plain language, the 4 corners of these 2 deed documents. This is the evidence that the plaintiffs have submitted. There is actually no reference to any type of misconduct, emotional distress, malice, any sort of threat of physical injury. And there are certainly examples in the case law, Your Honor, for when intentional infliction of emotional distress is appropriate, and none of them are triggered here. Your Honor, it is certainly understandable, and I believe that the Thompsons are not happy about the fact that they lost to the Reeds in the Luba case and in the Court of Appeals case in which Ms. Andrach represented the Thompsons' opponents. But that does not give rise to an emotional distress claim. It simply does not. It also does not give rise to a wrongful use of civil proceeding claim. If we look at section 4 of our brief, starting at page 12, the elements to establish the claim for wrongful initiation of civil proceedings are, 1, the commencement and prosecution by the defendant of a judicial proceeding against the plaintiff. They fail on element 1. The representation at issue was actually filed by the plaintiffs. It was an appeal of a land use decision and then an appeal of Ms. Andrach's clients prevailing at Luba to the Court of Appeals. The Court of Appeals affirmed. So both of those proceedings were filed by the plaintiffs, not the defendant in this case. Element 2, the termination of the proceeding in the plaintiff's favor. Again, Luba upheld and the Court of Appeals affirmed. Those matters were terminated in defendant's favor here because defendant were the Reeds, and we have this even further separation of Ms. Andrach representing the defendants in that action, but the principle remains. And then the third element is the absence of probable cause to prosecute the action. Well, certainly that can't be true because the action was decided in favor of the Reeds, upheld at Luba in favor of the Reeds, upheld by the Court of Appeals in favor of the Reeds. And then number 4, the existence of malice, or as it is sometimes stated, the existence of a primary purpose other than that of securing an adjudication of the claim. And element 5 is damages. Your Honor, again, looking at the evidence, the 2 deed documents, the Thompsons don't meet any of these elements. And again, that's assuming, even if it were true that Ms. Andrach drafted and filed those deeds, they still don't meet even one of the elements of a wrongful use of civil proceeding claim. Your Honor, in reviewing this record, it is extensive. There is no doubt a dispute. It has been going on for years. There have been multiple attorneys involved. There have been multiple bar complaints. There have been complaints against the officers of this court. The rules don't allow the party to a proceeding against their neighbors, or in this case, at least 34 that I counted, different matters and proceedings, this dispute with their neighbor. The law simply does not allow for one party to sue and maintain a claim against the attorneys who represented their adversaries, particularly under the circumstances here. There is simply no evidence that anything Attorney Andrach did, those 2 deed documents, the evidence at issue, that supports any of the Thompsons' claims. And so with that, Your Honor, I'll rest for now. We're happy to hear from the Thompsons and then respond.
Thank you. Mr. Thompson.
Just some involvement here. Here we are. Number 1 is this constant reference to the Reeds. The Reeds. Exactly who are we talking about when we're talking about the Reeds? Who did Lisa Andrach represent? There was a filed declaration of Lisa Andrach in support of quashing a subpoena that you've probably seen, where she states that she represented Robert and Donna. Well, I believe she did. I don't know if she ever represented Robert Jr., Kim Reed, and Karen Reed. She obviously handled things for them, but in initiating all of this, Lisa Andrach produced a new version of the deed for the senior Reeds. And that's the deed where she changed the wording with respect to our easement. It's a very big deal. It's our easement. Then, I don't know what Ms. Kuchar Katura is talking about when she says she drafted and filed. Do you know what she means by filed? Because she didn't record it at the county recorder. Robert Kim Reed did that. Not only that, Robert Kim Reed testified in court that he was the person who altered the deed. Openly admitted it. Then he said that it was a mistake. But then he followed that up by saying that he had consulted two attorneys and that they both told him that the meaning was the same. Well, obviously it wasn't a mistake, or all kinds of people were making the mistake, and it had to do with our easement language on that deed. So we have, this was done. This is one of the exhibits, Exhibit B. It says, after recording, everything about this says it was produced by Lisa Andrach at Fitch and Neary. But Robert Kim Reed made the claim that he did it. And you see, when it gets recorded, it's completely changed the format. So Robert Kim Reed, with whoever's help, took this document, copied and pasted it without the Fitch Law Group information on it, and claimed it as his own when he recorded it as the county clerk, knowing that it had been falsified. So this was done originally in, I think, November of 2020. Well, they had the consideration as $1. So then, a few months later, they decided, well, they were going to change that. So they went through this whole routine again, produced yet one more falsified deed, and changed the consideration to love and affection. And then that deed was taken with the same thing, transposed by cut and paste, apparently, by Kim Reed, and re-recorded again with the same falsified language that had already been pointed out to them. There was never any effort made to correct that deed. So this deed has to do with an easement that's part of our deed. It controls our constitutional right to enjoy our property. Take away somebody's access to their home. You want to see intentional infliction of emotional distress? It doesn't get much bigger than that. My wife lost her job. She couldn't deal with all the harassment on her own driveway. I mean, it's limitless. So we have that whole aspect. And then we get to the privilege. Well, who has this privilege? I'd like to see it laid out a little more clearly, just exactly who Lisa Andrach was representing and when. There's some big questions about that. This whole thing gets presented like, oh, the Reeds, like Hatfields and McCoys. Lisa Andrach has used that terminology. That's not it at all. We simply want to be left alone to enjoy our property and our rights to our property. And yet, we're having a great deal of difficulty doing so. If there's anything similar in these cases, from my point of view, is that these attorneys just can't resist taking advantage of the weak mental character of members of the Reed family, primarily one, for profit. And they don't care what the fallout is. So that's what we deal with day in, day out. It is essentially an interim jurisdictional thing. The deeds are the only thing. They have to be upheld. They're specific, they're simple, and yet they've been totally perverted ever since the Reeds didn't get to own our property, and they won't. So, but that's the effort, and boy, they don't want to give up. So what do we have? The whole Bar Association Professional Liability Fund going to war for them? We're not going away.
Mr.
To
Thompson,
speak
it
to
would,
this land use business
Go ahead.
a little bit.
Yep, go ahead.
Totally perverted. This whole land use process was based on a falsified deed. And there's all kinds of language and documents based on Lisa Andrach's forgery of this deed that influenced that whole process. We have emails that we got in discovery, I'm sure inadvertently, they're very incriminating, telling from her to Kim Reed, go easy on the easement until the land use stuff is over. The land use process was entirely perverted. When it came time to appeal out of that, the hearings officer just rubber stamped what the county planners did, which was all wrong. County commissioners refused to even hear it. So then it went to LUBA. County attorney D. Adam Smith failed to forward the record to LUBA, so LUBA couldn't make a decision, so they just affirmed. And then same thing on, nobody could do anything because Adam Smith refused to forward the record to the LUBA and the Court of Appeal. So that it isn't a clean cut, is that they rubber stamped and said, yeah, this was really good because the rights have been violated. And the rights can't be taken away. They can only be violated. And violated they have been.
Mr. Thompson, what the court has to focus on for this proceeding today is whether or not you and Mrs. Thompson have provided sufficient evidence to show that there's a probability that you will prevail on these claims. And so I want to give you an opportunity, if you want to so take it, to walk through the elements of each of these claims, just as Ms. Kuchera did, and explain to the court what evidence you think you have supplied to satisfy those claims.
Okay, let's see, let's see. We have a reply and support here. No, Ms. Kuchera's document there. So basically, the evidence, Your Honor, while we look for this, is these deeds. I mean, it's clear as a bell. Nobody can argue that they weren't falsified. It's a crime. Then they were transported some way or another to another person. Possessing a forged document is a crime. Recording a falsified document is a crime. So we have all these crimes, and then they repeat the whole process all over again. Owning a device used for forgery is a crime. Computers in these cases were used to do this forgery. They became crime implements. It's all very clear just looking at these deeds. So to go through these for the court here. Speak to these things. We've certainly read these. I think the background is clear. Basically, I understand where the court's going here, but our belief when we first saw this was that this is a sham filing because anti-slap. Well, there's no slap to be anti-slapping. We're not trying to stifle free speech or access to any kind of information. They are. I mean, we're the ones who should be filing an anti-slap action. This is meant to interfere with free speech and free information. So the evidence being in those deeds, I mean, it's substantial. It is very substantial. Everything is based on that, and there's nothing. I'm not even hearing an argument about that. The forgery. claims, this, all this reference to the defendants and the clients, and leave the clients out of it. We don't even know who these clients are. The fact is, Lisa Andrach forged a deed multiple times. She did it for one party who was granting the party to another party. I don't know how appropriate it is for someone to represent both sides of a property transaction in the granting and grant, recipients of as grantees of a deed. But this was all done in very questionable fashion here, and it caused a lot of problems. And the information at hand isn't privileged. It's out in the open. It's the deeds. They're even recorded, and they're still recorded, and they haven't been corrected. So that's a problem, because our ownership in that piece of property was verified by that easement. It's our easement. It's not anybody else's easement. So it's part and parcel of our property and ensures the benefit of full right of property ownership. And interfering with that is a pretty major contractual interference. And everybody who owns property should be very concerned about this kind of thing. So I'm trying to work through here, and I'm not sure exactly where I am. Do you have?
But do you want to just go through our claims, our causes of action?
Well, I think we're dealing with the motion. Am I correct?
Causes of action.
Yeah.
Mrs. Thompson is directing you in the way that I asked my question.
Okay.
So, there's the first claim for relief, and it talks through that.
Would you like to talk?
No, but
Okay. Well, first claim for relief, tortious interference. I mean, the deeds were altered. And even after being told about it, nobody wanted to rectify that. So I just don't see how that can be overlooked anywhere. I don't see how it can be overlooked by the county. I don't see how it can be overlooked by the district attorney's office.
here's your second.
And then we have the intentional infliction of emotional distress. We have Lisa Andrach representing, presumably, at the early point of this, I don't know when it all changed, or what there was both. She claims that she only represented Robert and Donna Reed. Donna Reed have made a lifelong cottage industry out of inflicting emotional distress on everyone around them, including me for 10 years. They were hoping to obtain my property, and that didn't happen. So all they can do is wage war by way of this deed, and it's very intentional. And we have dealt with a lot of, you know, a lot of that already. Okay. Wrongful use of a civil proceeding. So, what civil proceeding were we talking about? The entire land use process that Lisa Andrach was behind, starting with her forged property deed. The evidence there is quite clear. And then it follows through, but it all commences and depends on that forged deed.
So, Mr.
And that's
Thompson,
how it began.
one moment. Mr. Thompson, which judicial proceeding are you indicating was commenced by Ms. Andrach?
The land use proceeding, the county land use process, everything was done improperly. There should have been public hearings when there weren't.
One moment, though. I would just want to be clear. Your position is that that proceeding was initiated by Ms. Andrach on behalf of her clients.
Correct. Yeah.
All right.
The applications were made by her and all other kinds of people. The file is huge. That ended up in a house being built that should never have been built. The front door to this house is 35 feet from the edge of our easement. Who in their right mind would do that? Nobody. They're going to have a hard time selling that house.
Okay, and the second question I have is related to the wrongful use of a civil proceeding claim. The land use proceedings, whose favor did those terminate in?
Well, in my view, they didn't really terminate in anyone's favor. They just terminated for lack of, as I explained, D. Adam Smith failed to, it was his job as a county attorney to forward the record for the proceedings to LUBA. He never did that. So, is it his fault? It didn't start with him, but he kind of finished it off there before he was termed from the county, along with senior planner Cynthia Smith. By the end of this process, they were
Mr.
both
Thompson, the
termed.
court would need to find evidence that those proceedings terminated in your favor. Do you have evidence that that's true?
Well, I guess insofar as you could say, they may not be fully terminated because, there were a lot of things done poorly and a lot of harm done that fall into the area of deprivation of rights, which is a federal question. And so, that's an area this left at this point. So after failure to provide a record, so LUBA can't do anything. I don't think much of LUBA anyway. And then the Court of Appeals, well, obviously you don't appeal that to the Supreme Court because the whole thing has been totally, the process has been destroyed by everything, including the beginning with a falsified deed. The thing never would have gotten off the ground had that not been done.
Thank you. I don't have any further questions. Is there any further argument you want to make?
Well, I guess just to make it clear, one of the things that came out of this was the county, based on Lisa Andrach's deed treatment and confusion over our easement, the county somehow decided that they could grant the Reeds our driveway for this house, which they can't do. They can't alter a deed. They can't say who owns what property or not. But that's what happened, and that's a daily problem. And has been, it will be, until something settles that business, because we're being trespassed daily. We're being abused on our own property. We can't come and go to our own home freely. We're afraid to leave home. We're afraid to both be here in town at the same time for fear of what might be going on there, because we've had some pretty horrible things take place.
Thank you.
So,
Ms. Kachar.
Yes, thank you, Your Honor. We heard Mr. Thompson repeatedly express his displeasure with Deschutes County, the Deschutes County District Attorney's Office, the Oregon Court of Appeals on the land use decision that was then upheld by LUBA and affirmed by the Court of Appeals. As Mr. Thompson pointed out, the appropriate remedy for displeasure as to the outcome of the Court of Appeals case would have been an appeal to the Supreme Court. That didn't happen. Those decisions stand. This court must give full faith and credit to that action. And a request here to remedy something that was ostensibly wrong during that proceeding, which has now concluded, is an improper request for reconsideration. That's not the claim they filed. That's just not procedurally appropriate. We also heard Mr. Thompson repeatedly talk about the actual underlying issue here, which is Robert Kim Reed altering the deed. He speculates, Mr. Thompson, that Mr. Reed did so at the advice or while he may have been represented by Attorney Andrach, but that is pure speculation. Mr. Thompson said multiple times he doesn't know who Lisa Andrach was representing. That simply means that the Thompsons' claims fail. I understand 100% that they are upset with their neighbors and with the alleged actions of their neighbors, one of which appears to be this alleged forged deed or the alteration of the deed. But what we heard Mr. Thompson say, and what I understand to be correct, is that Ms. Andrach never reported any deed, that these were deed drafts that may have been provided through this course of some representation of Ms. Andrach, but that the Reeds, according to the Thompsons, Robert Kim Reed is the individual whose actions are at issue, and Mr. Thompson admits he doesn't know whether Ms. Andrach represented Robert Kim Reed or whether it was other Reeds that Ms. Andrach was representing at the time of these supposed behind-the-scenes activities. Nothing that we have heard has provided sufficient evidence that the Thompsons can support any of their claims against Ms. Andrach. My argument stands. I don't believe I need to clarify anything else unless the court has questions.
Thank you. No questions at this time. All right, we will, the court will issue written opinion. Oh, do you have something to add? Briefly, sir.
Yes, very briefly. It is evident in these things that the progression of what happened, it states in the little footer of these deed documents produced by Lisa Andrach that her clients, but she says that she worked for Robert and Donna Reed. So there's a natural logical progression. Lisa produced these. She was hired to do that by Robert and Donna Reed with full intention. Then they sent it to disguise a trail a little to their son, Robert Kim Reed, who printed them off, I don't know, on a Forest Service computer, home computer. Then he delivered them to his parents, who then take them to have their signatures notified, to a notary. And then he takes them and records them. Everybody knew what they were doing here. Nobody can claim they didn't know. Lisa can't claim she didn't know. There was an intentional alteration of a property deed. It was pointed out to them in the land use process. And what did they do? They turned right around and did it again 5 months later, changing the consideration. I don't know what that means. We have a problem here of a falsified deed. Everything I've read about a falsified deed makes it null and void. It's no good. And so ultimately, the ownership falls back to the grantor. So everything being done on behalf of the new grantee, Robert Kim Reed, Karen Reed, is completely null on that basis because they weren't the owners. It's really that simple. So all this harm was done. Nobody stopped at the beginning and said, okay, let's do this right. Let's get a declaratory judgment to just line out what all these details are before we do anything. It was like, let's see what we can do to rush this process through and do all this damage and then deal with the fallout later. And that's where we are now.
Thank you. All right, the court will issue a written opinion. We will take a 15-minute break, and then we will come back and we will take up the second matter of 23 CV 49245. So we will be back at 2:40. Thank you.
Your Honor, just briefly before we go off the record, there was a plaintiff's motion to strike our motion to strike. Was that something you needed me to address here, or is that something that we will address today? I'm going to stick around. I just wasn't sure if that's something the court wanted to take up right now.
I didn't see that on our notice of motion, but one moment. It seems that it's probably would make sense to address it. Let me just look.
And for the court's reference, Your Honor, it was filed January 18th.
Thank you.
And then our opposition was filed January 30th.
All right, we will take that matter up now at this time. So, Mr. Thompson, you have filed a motion to strike, the special motion to strike. We'll all hear argument on that at this time. Go ahead.
Okay, I'd like to take a minute here to kind of get caught up.
Yeah, that's fine. This is your motion that you
Yes.
filed, it looks like on January 22nd. Are you following, sir?
Yes.
Okay. Whenever you're ready.
And I'm sorry, Your Honor, that was correct. The January 18 date was in the other case. It is the January 22nd date for case number 23 CV 50050.
Thank you.
We have the front page, but like I said, it's very short, right?
It is very short, yes.
I kept looking at it.
In fact, the court's copy is 3 pages, including the certificate of service.
Yeah, so just in looking through these, we conferred on this motion, and we feel that the court has the authority to strike the defendant's motion under ORCP 21E. Did a lot of digging around to come up with that one, actually. As I stated earlier, that we believe that the defendant's motion is a frivolous and sham filing, and I believe done just for dilatory purposes, and also to obstruct any possibility of conducting discovery in these matters, which would answer a lot of the questions that have been raised. So, yeah, basically, we see it as filing a defense in the case, and not simply a special motion.
Thank you. I understand the argument, Ms. Couture.
Yes, thank you, Your Honor. The motion to strike is simply procedurally improper. The way to oppose the motion to strike, our special motion to strike, was to file a response in opposition. The Thompsons did that. With respect to a motion under ORCP 21, they simply have not cited to the rule, have not specified the nature of the ORCP 21 violation that they allege is present. They have not asked for any more specificity for us to make it more definite and certain. The motion to strike simply fails under ORCP 21 and again is procedurally improper under ORS 31150. Thank you.
All right, thank you. Okay, the court will issue written opinion, as I previously indicated. We will now be back at 2:45. Defendant's special motion to strike. Mr. Steele, when you're ready.
Thank you, Your Honor. Unfortunately, you're going to hear a little bit of what you've already heard today, and I apologize if this would have been one transcript or one recording, then I think we could have disposed of a lot of what you're going to hear because you've already heard it, but bear with me as I go through some of the analysis with respect to ORS 31150, which is the anti-SLAPP. I suspect by this point this court has realized that underlying this current lawsuit that's before the court today, There is a very long and acrimonious history of litigation between the plaintiffs and a family named the Reeds, and this dispute really has ostensibly involved the dispute about the use of an easement that is located between these parties' properties. And unfortunately, because of that dispute, and of course it involves property, this dispute has, I think by my count, has spanned about 12 years of litigation and involving many, many lawsuits, and involving even a criminal conviction against Mr. Thompson. It's certainly unfortunate, but my clients, Mr. Reinecke and his law firm, Bryant, Loveland, and Jarvis, their only involvement in this, on these cases, has been as the attorneys for the Reeds. And their representation of the Reeds started in about approximately 2014. So they have been involved in this for a period. The scope of the litigation has more recently, in the last couple of years, spilled out of just a dispute between the plaintiffs and the Reeds. In the last couple of years, they've initiated a separate lawsuit, a federal lawsuit against Mr. Reinecke. That was dismissed. And they have more recently obviously filed this action and filed now their action against Andrach. So apparently the litigation has shifted somewhat in terms of who now is the focus of the litigation. Before, obviously, it was the Reeds, and now it seems to be those who represent the Reeds. And our position is that this lawsuit is just yet another iteration of many of the claims that the plaintiffs have made, the misguided legal theory claims that have been asserted throughout the history of this case. In the present lawsuit, they assert three claims for relief. They assert a claim for tortious interference, intentional infliction of emotional distress, and wrongful use of the civil proceeding. All of these claims that they're making and the facts underlining them arose out of judicial proceedings, meaning that the way in which they frame their complaint clearly demonstrates where they believe the source of these claims arise. And just a real quick cursory, in the first claim for relief, they allege, among other things, that defendants made false statement in court records, allege wrongful conduct in connection with statements regarding a hearing, and then make a general allegations that defendants have abused and misused the judicial system. The second claim for relief says that defendants engaged in general public humiliation of the plaintiffs before the courts and court staff. Third claim for relief includes allegations that they engaged in many false and frivolous legal actions. So I think there can be little doubt as to where, given the fact that my client's only involvement has been as lawyers for the Reeds, that these claims arise out of conduct that the plaintiffs believe that, or at least they perceive as being wrongful in connection with these numerous lawsuits. We have filed, as the court knows, an anti-SLAPP motion under 31.150. That statute, although it's got a long history and I want to get into it today, but really is intended to ferret out claims in which are based upon the privileges established in subpart 2 of that statute. And I want to read it for the court. The court's already heard it, and I'm sure can read it in the briefing. But most importantly, it's very broad, and it encompasses not only statements, both written and oral, but also includes any documents connected in connection with a litigation or judicial proceeding. That's pretty broad. And in this case, if you read carefully, and I know you have all the pleadings and the attached affidavits, really what they're getting at is the conduct the defendants, they believe, engaged in during the course of these litigations, whether that's statements to the court, whether that's filings, whatever the case may be. So from our standpoint, it's clear that these allegations arise out of conduct that's privileged under subsection 2. If this court concludes that that is correct, then the second part of the statute kicks in, which is the burden shifts from us to establish that these claims arise out of a judicial proceeding. And then it shifts to the plaintiff to, and I want to make one correction earlier, it's not just sufficient, it's substantial evidence. That's what it says. Establishes that there is a probability the plaintiff will prevail on claims by presenting substantial evidence to support a prima facie case. And by the way, case law in Oregon says that the evidence not only has to be substantial, but that it has to be evidence that would be admissible at the time of trial. And that's really the purpose of this, is to ferret out whether or not this is a meritorious claim. It is the plaintiff's burden to produce evidence that would be admissible at trial to substantiate each of the elements of the claims by which they're making. That is a burden, and it's a significant burden. And in this case, they've alleged, as I've mentioned, 3 claims, and each claim has the separate elements set forth. They need to establish by substantial evidence sufficient to create the probability they're going to prevail at trial to establish each of those elements. And in this case, and what they've done is really provided no evidence. And I will go through it for a moment, but before I jump ahead to the evidence, I think I would be remiss if I didn't mention that I think the first part of the court's analysis has to be whether they even state cognizable claims, meaning before we get to the elements and the evidence, do they even state claims? And you've heard earlier, and we will reiterate, that the litigation privilege does apply and would shield Mr. Reinecke and his firm from any liability for conduct in connection with their representation of the Reeds. The court mentioned earlier about there are exceptions. Yes, there are. And I think case law and a general preview of the cases suggests that, one, it can be situations in fraud or situations in which the plaintiffs can show that the lawyer engaged in malice. And that's a high standard because you have to show, independent of the adjudication of the case, that the lawyer was engaged in some separate conduct, arguably operating out the scope of their representation to engage in conduct that is wrongful, has an alternative motive and purpose that does not relate to the adjudication of the case. And again, it's a difficult burden, but it's the burden they face in suing their opponent's lawyer. And none of those exceptions would apply here, at least with respect to whether they have provided sufficient evidence to establish that exception here. And of course, that is the burden the statute puts on them. The response itself is a little unique, and I understand that they are not lawyers, and so I think we all want to give folks the benefit of the doubt. Their response, from our viewpoint, is nothing more than a narrative of, I think, what the plaintiffs, how they view the litigation history, how they view the Reeds, and in some instances buried in there, how they feel about the defendants. Most of it's very conclusory. Most of it is based upon opinion. And, I don't think we're here to judge the Thompsons with respect to their view of how the things have occurred, but that's not going to get them over the hump, because today they needed to submit substantial evidence to get over the hump, and they just haven't done that. The only way that it appears that they are trying to get around the fact that they have failed to provide substantial evidence with respect to each of the elements of their claims. I mean, here's just one example. Each claim requires the element of damages to establish by affidavits, by documents, whatever the case may be, that they've suffered damages, and they haven't. They don't even address damages as any part of their claim, which is alone fatal. But nevertheless, the way they get around it, I believe, is they're asked the court at the very conclusion of their response, or somewhere in there, to have this court take judicial notice of everything they've submitted, to have the court accept as true fact everything that they've said. And I want to just point out that ORS 40.070 says a court can only take judicial notice of a fact that is not subject to a reasonable dispute and capable of accurate and ready determination by resort to sources whose accuracy cannot be reasonably questioned. Again, a very high standard in terms of what is required to get the court to accept a judicial notice. I believe Ms. Thompson's affidavit sums up their position fairly well. She states in there that this court should take judicial notice of the entire history of the litigation, which aligns with plaintiff's objectives. See, so what I think they fail to understand is the court can't take judicial notice of a party's opinions or the viewpoints of a party, as that would be obviously subject to reasonable dispute. And of course, we do dispute about everything that they put in their pleadings and in their supporting affidavits. The other thing I want to address, I just have two more points, which is I want to answer the court's questions with respect to each of the elements, because that could be, we briefed that, and I don't know if the court wants to get into establishing the elements. Our position is simply that they haven't established those elements for each of those. There is one other problem, fundamental problem with their alleged substantial evidence, is that their affidavits are defective on their face. And the affidavits that they've submitted are, and the first one is by Mr. Thompson's, but I think it's a little bit of a stretch to say it's an affidavit. At the very conclusion of his response, he adds some language that seems to suggest that that the response is serving both as a response, a pleading, and also an affidavit. However, all that he does is attaches language, cuts and pastes language from a federal statute, 28 USC section 1746, that deals, it's a federal statute that describes what has to be involved in an unsworn declaration. The affidavit by Ms. Thompson cuts and pastes the same language. Here's the problem. In Oregon and under Oregon law, affidavits and declarations, in order to be admissible, must comport minimally with the requirements of ORCP 47. There, it requires a sworn statement, testimony, that must be accompanied by a clear statement that the testimony provided is based upon personal knowledge, setting forth facts that would be admissible at trial, and affirmatively show that the declarant is competent to testify. In Jeffries versus Mill in Oregon Court of Appeals 165 ORAP 103, the court held that if the trial court cannot determine whether the statements in the affidavit are based upon personal knowledge, then the court has to exclude those as either lacking foundation or impermissible hearsay. With respect to Mr. Thompson's affidavit, it really is just the response. And he signs it both as the party who is submitting it, but also says it's an affidavit. I think a cursory review or even a detailed review of that would show that most of it is just statements that he's making, or viewpoints. But again, that's not evidence. That's mostly just opinion and hearsay. He doesn't support it by an independent affidavit. And even with respect to Ms. Thompson's affidavit, she doesn't include any statements that's based upon personal knowledge. And most of the statements are just generalized conclusory statements, and then it attaches a lot of exhibits of which really no foundation is laid for them. There are letters in there written by parties, other parties, which is hearsay. There is a transcript in there of the court. It's not very clear based upon the reading why they attach that or how it supports their case. And I don't want to get too far into the woods because I suspect the court has read all that, but I would just say this. What in the totality of the information they have provided, what is lacking is any cognizable relationship between what they've submitted and the elements of the claims in the lawsuit. And that's the problem, the disconnect. And for that reason, under ORS 31.150, their lawsuit has to be dismissed. That is what the statute says. So we're asking this court to, under ORS 31.150, to dismiss their lawsuit because, one, it's privileged in terms of the allegations, meaning it rises out of a judicial proceeding, or involves work by a lawyer who's on the opposite side of them, and also they've provided no substantial evidence to show a probability that they will prevail at trial on any of these claims. So unless the court has any other, I appreciate your patience, but that's all that I have. Thank you.
I don't have any questions. Thank you. Mr. Thompson?
Well, to start at the top, with some notes, Mr. Steele loves to just pounce on this word criminal conviction. You know that whole story very well. Why would this be an issue here? Because it's an intentional effort to besmirch my reputation, which I guarantee my honor and integrity are 1,000 times higher than every member of the OS bar. The only involvement as an attorney for the Reeds, one of the major issues here and purposes of filing this lawsuit is that, as you're also well aware, we have filed 4 lawsuits against members of the Reed family for tortious conduct involving summoning of law enforcement for improper purpose. There's a long history of this. There's evidence in emails of many kinds of Mr. Reinecke being the driving force behind doing that. And so now we have another issue that I'm sure you're aware of him representing these people. Well, I don't think he should be, because he's actually one of them. He is the driving force, inspiring these people to make all kinds of false claims and bring in law enforcement on my property, to my house. Now, how can you interfere with somebody more than that? Another example is these filings of contempt. I've never been in contempt of anything, ever. But a lot of other people have. They've been in contempt of my constitutional rights. They violated my rights. Mr. Reinecke somehow negotiated in the back rooms of across the way here an item of have a duty to close the gate. Okay. If you read that judgment, there is so much vague nonsense in there. It was all drafted by Mr. Reinecke here. What does that even mean? It specifically says that I, as a plaintiff, have a duty to close the gate when using it to prevent livestock from challenging it. You know what that means? I don't know what that means. You have so many things. Where's the duty? I haven't contracted with anybody. You can't impose a duty on a person. That's involuntary servitude. It's slavery. It was abolished a long time ago. Plus, it's my easement and my driveway. It is my right to enjoy that. So there you have a problem. Then you have, oh, he didn't close the gate. So, oh, that's contempt of court. That's not contempt of the court. That's standing up for the United States Constitution, standing up for my rights. So how is it contempt? Then we go through a few things, changing words and initialing this and that, and well, is it or isn't? And we have people harassing us. They drive them half a mile down the road to interfere with our access at this gate in the complete absence of any kind of livestock. To make a big deal of this and call that contempt, it's absolutely outrageous. So that's a continuing thing that is still before the court and totally unsupportable. So we also have the case of 21 CV 25146, which was dismissed by the court and which has been sitting in limbo land with the Court of Appeals. Who knows where that would be, but all of this amounts to nothing more than a tremendous effort and expense to interfere with our rights. So anti-SLAPP, where's the anti-SLAPP committee? Yeah, you can come up with little items to tick off, but it still doesn't get past the basic intent of anti-SLAPP legislation, which is intended to stifle free speech. And we're not doing that at all. So to get back to these ORS 30.845 lawsuits, these people, I filed a lawsuit against one who did something, and this is mushroomed into a much bigger thing. There's a massive lawsuit against the Deschutes County Sheriffs resulting from this. That would be, I mean, like, I'm 75. Do I really want to be playing this kind of game? No, I want to be left alone. I want to come and go. I want my wife to be left alone, be able to come and go in peace, as happened has always happened in my life until the Reeds decided that they want my property. So the claims, there you have a frivolous, continual references of using the word contempt. Where is the contempt? It's not here. It's out there. So malice, how is that not malicious? Mr. Reinecke encourages all of these family members to call the police and make up things, to summon the police to my property, to harass me, to threaten me. So how do I defend myself? That's all because of Mr. Reinecke. He filed into 21 CV 25146 complaints that actually stated that that's what they should do. Call law enforcement, a warrant for this, a warrant for that, a warrant for this. What kind of evil, malicious activity is this? So, and how's that working out for these people? They committed the tortious act, plain as day, under his direction. And now he's going to defend them against that. I don't know how that's going to play out, but it's going to get pretty interesting. The affidavits. I'm reading through the special motion 31.320 stuff. Affidavits and declarations seem to carry a lot of weight in that, in making a determination. Nobody else has submitted one. At least Andrach didn't submit one there. Mr. Reinecke hasn't submitted one. Nobody else has submitted one. Zero support from affidavit or declaration. My affidavit was in a form. It was notarized. It was sworn to. That means that I'm happy to come into this courtroom or any courtroom and testify to the truthfulness of it in any aspect of it. So this isn't just a matter of filing a lawsuit against somebody's lawyer. It doesn't really kind of make a lot of difference who the people are. It's what Mr. Reinecke did. The acts are malicious. Judicial notice. Mr. Steele brought up judicial notice. Well, he filed the motion, and on the footer of the front page, he goes into requesting that the court take judicial notice of every filing in all of these cases. Well, I think that's highly inappropriate and quite impossible. And like, how does the court do that? What is he setting up here where he's going to go back? And so in response to that, I went back to the very first thing that brought me into this courthouse was Robert Reed Sr. and Donna Reed filing a totally fictitious claim against me for a restraining order under the Elder Abuse Act and having Judge Arthur Brady give it to him based on no evidence of anything. In fact, what had happened there was that they came over to my house and assaulted me at my house. So I look at the Elder Abuse Act, caregivers and people in charge of the finances. Oh, sorry, that's not me. It was Judge Adler dismissed it. So I thought, well, I'm an elder. I'm the one who actually needs some protection here. So I turned around and filed for a restraining order against them to leave me alone. In fact, in 2012, that wasn't granted. We have asked this court for countless protective orders to keep from being harassed, coming and going to our own property. And they all get denied. The last one, I'm appealing. I just had it. And so my wife had to quit work at the harassment coming and going at our gate, day in, day out, all hours of the day, all hours of the night. It's absolutely horrendous. So this transcript brings up another issue that Mr. Steele brought up. That's a transcript from a court case with Judge Miller, where in it, Judge Miller is talking to Mr. Reinecke, and it's on the record in the transcript. Yeah, when we talked last night, what are they doing having conversations the night before a trial outside the courtroom? And what else went on? What was the substance of these conversations? They shouldn't even be happening. And yet that seems to be a routine tactic of Mr. Reinecke's that falls outside the proper judicial representation for his clients. We had a hearing down the basement part of Reinecke. Mr. Reinecke puts a briefcase on the floor and uses his foot to slide it out in front of the table before leaving. I mean, it was so obvious. We have photos, we have the video of it. It's absolutely disturbing. I've yet to hear the final story on it. What's the chain of custody of that briefcase? What was in it? Who was it for? So these kind of shenanigans are what are behind filing this lawsuit for tortious interference. And let's see, as far as any kind of privilege, well, there's so many examples of fraud involved that I couldn't even count them. And fraud is not protected. So I think this is all just an effort to again thwart any kind of discovery, thwart any effort from the court to get at any truth about anything, and I don't think it should be dismissed.
Thank you. Final argument, Mr. Steele.
Thank you. I'll keep it very brief, Your Honor. I think, if anything, what Mr. Thompson has argued today confirms our position in the case. I think three things are important takeaways in connection with his arguments. One, this is an unfortunate situation. The litigation's gone on for 12 years, and I suspect from the Thompsons' perspective, this has been a very frustrating situation, and even more so when parties who are unrepresented by lawyers, they view things a certain way, and they view the legal system a certain way, particularly if it doesn't turn out in their favor. And it can sometimes cause people to view things in a way that maybe doesn't comport with reality, but it's true for them. And I think what we can take away from Mr. Thompson's position is that he believes, I think, what he is saying. I think he believes that some of this may have occurred. The problem is someone's belief and conviction about something is not evidence, particularly in this setting, when you have to furnish substantial evidence that you would prevail at trial. He made many conclusory statements. There are, I think he said, there's fraud, okay? But you have to prove that. He goes on to say that there are acts, many, many acts of malicious conduct. But that's the problem, right? I mean, from his viewpoint, he sees things a certain way. But you have to submit evidence, substantial evidence, not to support what he believes, but to support the elements of the claim that you're bringing. And here, he just hasn't furnished substantial evidence to support any of these claims. And just because you may believe it or just because you say it doesn't make it fact or evidence. And I think there is a distinction there that the court can draw. And it's just, they haven't done it. And for the reasons I've already stated. And so for that reason, this case has to be dismissed under ORS 30.150, simply because they have furnished no evidence in support. So unless the court has anything else, that's really all that I have to add.
Thank you. Let's take up the motion to strike the special motion at this time as well. This was the same motion, Mr. Thompson, that you had filed in the other matter, asking the court to strike the defendant's motion pursuant to ORCP 21E. Do you want to be heard further on that at all?
I believe that you heard the same argument that I believe applies.
All right, so you'd like me to adopt the argument you made in 23 CV 50050, that it is essentially I think you wrote a frivolous motion.
And just to be clear, everything that I say in affidavit and standing here is based on firsthand personal knowledge and nothing else. I'm not fantasizing, making things up. I know what I know.
Thank you.
Just-
All right.
Thank you.
And Mr. Steele, I have reviewed your response to plaintiff's motion to strike, the special motion to strike. Anything? Do you want to add anything?
No, I would just point out that the motion itself is very conclusory in nature. It just kind of lays out particular provisions and stating that in a very conclusory way that our motion and our slap motion is a sham and frivolous pleading. The problem is he doesn't really tell the court why. And under ORS 20 or UTCR 5.2 or 3, excuse me, 20, sorry. It requires every motion to be accompanied with points and authorities that lays out the arguments and to tell the court why their particular authority supports their position. And that's just lacking here. It's just conclusory statements. The other problem, of course, is UTCR 5.20 requires every motion where you are moving to strike under 21E to attach the particular pleading in which you're moving against. In this case, he would have had to have attached the motion, defendant's special motion to strike and include the brackets and things that you want the court to strike, and he didn't do that, and that's mandatory. So for those reasons stated in there, we're asking the court to deny that motion.
All right. Thank you. All right. That will conclude this matter. Court will.
Excuse me,
Yes.
Your Honor, do I get to respond to that?
Sure.
Yesterday at late in the afternoon, I received an email from Mr. Steele here regarding something he was going to file a response to the motion. Is that what he was just talking about?
Yes.
How was that time? I don't think that motion should even be recognized by the court. I get an email at late in the afternoon on Sunday, the day before this hearing. That's just, I feel that just isn't really acceptable. Use of people's time and abuse of the court calendar and everybody's calendar to even think about how to respond to that.
Okay.
So,
I understand the argument, sir.
I've
Go
got
ahead.
One more question. We noticed that somehow this, without any consultation with us, became somehow designated or identified as a complex litigation. So I guess we wonder just exactly what that means and how that came about and where we go with that.
The only thing I can tell you, Mr. Thompson, because it's the only information that I have, is that that is a designation that is made by the presiding judge.
That's my
The
understanding.
effect of it in this case is that I will hear all argument.
Okay.
That is the effect of that decision.
Okay.
I don't know anything more than that.
Thank you. It just kind of popped out. Well, complex. So,
All right.
okay, thank you.
Anything else for the court to take up today? All right. Court will be in recess. Thank you.
Thank you.
Thank you, Your Honor.